listening to Driving Law, a podcast by Kyla about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I am Kyla at Acumen Law, and with me, my co-host, Paul Doroshenko.
Hi, Kyla. Nice to see you. You look like you're warm and dry in the office.
I am having the worst day. I had an 8 a.m. meeting. I had traffic court in Port Coquitlam at 9:30, and I had IRP hearings at 9, 10, 11, 12, and 1. I also had traffic court in Port Coquitlam at 10:45 and traffic court in Vancouver at 1:30. So I've literally just been driving inches down the road, stopping my car, doing an IRP hearing, driving inches down the road, and I haven't accomplished anything today. And I am just like, it's awful.
You accomplished a lot. You did a meeting. You conducted a bunch of IRP hearings. You did dealt with two matters in traffic court. You got a lot done. Good for you. Anyway, I would have happily done some hearings for you because I can't be outside where I am between the rain and the mosquitoes. I am basically trapped while on vacation.
Well, I'm sorry to hear that. I don't
It's lovely here. I'm on Old Tejon Road. Old Tejon Road in Tejon, British Columbia. The bus turnaround at the end. The Fraser River is right there. Like it's about 4 meters past me. And I always worry because the river is barreling right down at this spot of the road. And then it turns here. And this is a bus loop for the school buses. And I always think if I was a student on a school bus, I'd be terrified of riding here.
Yeah. Well, anyway, I'm not feeling too sympathetic for you and your mosquitoes and rain situation on account of the fact that you didn't tell me before today that you could do the hearings.
I told you days ago that I could. You told me that I was going to have to do hearings today.
Oh, we had a conversation and you said, hey, since you've resolved your trial, now you can do all the hearings.
Well, you probably took over somebody else's traffic court matters. Somebody else from the office was probably going to cover them.
Nah, we got it retained on some of them just now. So.
Oh, okay. All right. Well, you should have let me know. The only thing is I have no internet at my place I'm staying. And so I have to drive down to this location where I have conducted hearings before. I happen to have 3 bars, so doing well. Anyway, let's dig into our driving law topics this week.
Yeah, so let's start by a follow-up on a case that we've been following on the podcast, the McRae case. If you remember this case, this was the decision, I believe it was Judge Guild, where Mr. McRae had gotten on his Bobcat in his backyard, and there was like a walking path, and there was this couple, and they were unhoused, and they were like biking on the path. They parked their bikes. They had a lovely little, seat in the grass. One of the people in the couple was not feeling well, and they were just hanging there. And this man gets his Bobcat,
Mr.
McRae, and tries to run them over. Was the allegation.
Well, he drives down there, and the conviction was that he pushed her, I think, and that she fell and ran a defense that maybe she fell because of heat stroke or something like that.
Yeah, well, there was a 4-day trial.
But he was disbelieved. He was, yeah.
Yeah, he was found guilty, and the relevant portions of the judge's decision are essentially that his evidence was rejected, that he didn't make contact with anyone with the Bobcat. He did. Obviously, the person he hit would feel it more than his Bobcat would cause him to feel it. There were tire marks and the tire marks are important to the appeal. There were tire marks that were caused by him, that were consistent with him hitting them and the other people's version of events. And he also threatened them effectively with the Bobcat. So
I think that threat was easy to make out, that's for sure. In any event, so he's convicted. Judge Guild, who is our theme of the week, maybe, I don't know, and appealed. So went to BC Supreme Court for a summary conviction appeal.
Yeah, and so basically there were 3 grounds to the appeal. The first was, that there was a reversal of the onus of proof on a critical point. The second, that the evidence on, the reasoning was misapprehended. He didn't appreciate the evidence. And third, and I find this one the most interesting, that he engaged in speculative reasoning without the necessary foundation. And, spoiler alert, we'll tell you the result because I hate it when judges do this. None of these grounds of appeal are successful. The conviction is upheld. Um, so the argument with respect to the reversal of the burden of proof was in relation to how, this woman, as you said, the heat stroke defense, how she fell to the ground when she was close to where Mr. McRae was operating his Bobcat. And that essentially Judge Guild had required him to prove that she was having a heat stroke, in order for that heat stroke defense to be accepted. And the
It was
court,
such a speculative defense. I mean,
yeah,
you've got someone, yeah, she might be hot, but she's got a Bobcat driving at her.
yeah,
Yeah.
exactly.
Um,
The Court of Appeal basically says, look, like on the one hand, yeah, in order for the Crown to prove the case beyond a reasonable doubt, they have to prove everything and disprove all reasonable possibilities arising from the evidence. But this is not a reasonable possibility that arose from the evidence that the Crown had to negate. And they don't have to negate every inference that could be drawn. So yeah,
yeah.
that one
That
didn't
that
work.
seemed like a bit of a stretch of an argument to me, but your client gives you the instructions on the appeal when you tell them what you
Look,
what you think might be an issue.
if you got big yard with walking path and Bobcat money, you may as well pay for a stretch of an appeal. Uh,
I suppose, yeah.
uh, yeah. So then the second one is this sort of misapprehension of evidence and speculative reasoning, and they kind of overlapped. But again, the court rejects both of these. Um, and the court says, speculative reasoning can be a type of misapprehending the evidence where, a judge draws a conclusion that doesn't logically or reasonably flow from the facts. And so the court combines these 2 grounds of appeal. And this really comes down to these like tire tracks, is what they were concerned about. That there was evidence that was misapprehended in relation to what conclusions the judge could draw from the tire tracks.
Yeah, I mean, ultimately, in the end, I think the court of that was hearing the appeal was looking at it and saying, "Look, in the whole circumstances of this case, you can look at the whole of the facts. You don't have to nitpicky or pick out searching for something that the judge didn't cover with the level of particularity that you would like. Ultimately, when you look at the whole, that the guy's driving a Bobcat toward people, like he's driving a Bobcat toward people. I don't think there's any denial of that. And it wasn't happy about the fact that he had these unhoused people were on his property and had a history of concerns of people being on his property. So,
Yep.
I mean, hard to get around those facts.
It is. So anyway, the 2 complaints in relation to this are, first, that she didn't expressly say she was hit by the Bobcat. She said, the machinery's approaching her. She saw the guy shoveling up her belongings. She tried to get him to stop, and then all of a sudden she's unconscious. Like, obviously the inference that she's drawing and that's clear from her sequence of events is that she got hit by the Bobcat. She didn't just get, like, hit by, I don't know, a flying toilet seat that fell from the space station. Like, anyway, ridiculous. And then the tire track thing, which I find
Even
so
if she's got no bruise on her or something from the Bobcat. Yeah.
so the tire track thing, um, in the trial, uh, the defense cross-examined this officer on these tire tracks that were, in photographs, and the defense sort of, was asking the officer to sort of give some information about what could be gleaned from the tire tracks. And the judge said, well, hold up. Like, be careful. You're not straying into asking the officer to give expert evidence on this, because if you are, then you're going to have a problem, because this officer's not qualified as an expert. And this was relied on by Mr. McRae on his appeal. He said, well, they curtailed my cross-examination on the tire tracks, but then Judge Guild relied on the tire tracks himself to say that, that he was driving in the way that the witnesses claimed because the tire tracks were inconsistent with his evidence.
Yeah. So, I mean, there's a couple of things there. Uh, he was right, I suppose, to point out that don't try and make him an expert. And you should be careful about what you should ask, but it didn't limit greatly what you could ask about it, especially in cross-examination. Number one. Number two, I think as a judge, you don't have to be an expert witness when you've got something so clear as mud, when you've got, I mean, clear as mud from tire tracks of a Bobcat. You can see that it's been driven around that location. I don't think you had to make the police officer an expert in tire tracks for that. But is it also a situation where you're talking about you need to know the exact distance between the two tire tracks to match it up to this vehicle? Do you need to look at the particular damage that's been done to these tire treads and match up that damage to the tracks? No, that's not what you're talking about. You're talking about Bobcat tracks that are still there and readily visible, right? We're not talking about some forensic photographs of tracks where you've got to match them up in a murder case. Like,
Just, just dumb. Like, and it didn't turn on like all the different various twists and turns and where he could have gone. It was tire tracks, people together, more likely that they got hit. In fact, proof beyond a reasonable doubt when taken together with the other evidence that they got hit by him trying to run them over with his Bobcat.
and you can just usually look at Bobcat tire tracks and know they're from a Bobcat as opposed to a tractor, as opposed to a pickup truck. Like,
Especially he was so proud of his yard and he didn't want people there. If there's tracks in this beautiful, wonderful yard that he didn't want people destroying, he put them there with the Bobcat on that uncontested evidence. So anyway.
I'm kind of surprised still that it wasn't a plea, but
Yeah. I mean, I don't know. I feel like with a plea, you probably do the right steps, could have swung a discharge. But
yes.
yep. Anyway.
Now he's got a criminal conviction, and criminal convictions for driving offenses are about to have a big different impact on people who wish to travel to the U.S.
Yeah, it's a big change. They're gonna make it they're trying to anyway. We'll see if the bill passes, but it probably will. They're trying to make it a situation just like in Canada, and we predicted this, that
Yes.
you would be criminally inadmissible to the United States for a DUI, which
Yep.
I did a whole TikTok on this when Trump got elected. I was like, this is gonna come. He's gonna do this. He doesn't want people coming to the US. This is one way to exclude people.
Yeah, basically any criminal conviction, but a DUI conviction has been grounds for inadmissibility in Canada since Stephen Harper's reign of terror. And now it's going to be grounds for inadmissibility to the States. And I guess you could say, as a tit for tat response, it's kind of, one government responding to what another government did 18 years later or whatever, but still.
Yeah. So anyway, you hinted earlier at this being sort of Judge Guild Day on the podcast. We also have a Judge Guild decision that came out recently from traffic court. Well, not
Surprised me a little bit. Well, no, it's an appeal or it's not an appeal. It's a application of a charter remedy. So lay it out for us.
So, this is Mr. Sean Newby. He gets a ticket September 4th, 2023 for using an electronic device while driving. He mails his dispute in, and remember, think back, November 13th, 2024, the notice of hearing document is created. So it's like, what, a year later that they create the hearing for him. And then it gets sent to him at some point, hearing date scheduled for January 28th of this year. And then that hearing gets adjourned because he doesn't have disclosure. And so then he argues that his rights have been violated. And so the question is, was this a violation of his rights, and who's to blame here? For all of
Oh, there's a postal strike in between.
Yes, this is the thing. So, the disclosure package that he got by email on January 27th, 2025, the day before the hearing. And obviously, given that it was the day before, he was self-represented. He's not in a position to obtain legal advice or review the disclosure. And his next hearing date is set for March 5th, 2025, which is only 37 days later, but it is long enough later that it is over the 18-month hurdle. It's set 37 days later. It's set for May 14th. Anyway, it gets over the 18 months. And there was the mail strike, as you pointed out. And this is the Crown, who they actually cross-examined him on this delay application, which I find is wild. Like, I've done a lot of 11B applications on traffic tickets. Most of them, the Crown just turfs them when they get the application. The ones that I have had to run, my clients have never been cross-examined. Like, there's one, another example of why you don't represent yourself.
Was he, did he have an affidavit? Did he file, or was it like cross-examined on the affidavit, or did he give viva voce evidence? If that's the case, then I would completely understand why the Crown would be cross-examining.
Yeah, I mean, it may be that he didn't know to file an affidavit and gave viva voce evidence.
They're stored up.
Yeah. So yeah, that's the issue there. The Crown didn't call any evidence, but then they said, well, Mr. Newby said there was a mail strike, and you can take judicial notice of when the mail strike is, and then find that because of the mail strike, the lateness of him getting his notice of hearing wasn't the court's fault. It was exceptional circumstances. He's trying to subtract the time frame that during which the notice of hearing was kind of in transit to him because of the mail strike, which makes no sense on its face. On its face, that argument is illogical because they generated the hearing date. It just didn't get to him any sooner. But regardless of that fact, the hearing date was the hearing date.
Yeah. In the end, it didn't seem to have a huge impact. Even if it did, government runs the postal service.
Yeah.
Different government, but still.
It's institutional.
It is a service that is, guaranteed to exist and function. If it doesn't function, maybe there's a remedy.
I mean, also wild that you you as the government are still sending notices of hearing by mail only. You'd think that those could be emailed. Be a lot faster, a lot easier.
Well, they have phone numbers for people too. Postal strike, pick up the phone, and the amount of time that it takes to print that thing out, you can at least send a text message. You could send a text. You could have some quick confirmation that you include in the file. Person was texted. We attempted to call, and we mailed out the notice.
Yeah,
We had an email on file. We sent an email notice of the email.
One of the other issues that came up in the hearing was the fact that Mr. Newby didn't make his disclosure request soon enough, according to the Crown. He should have made the disclosure request the day he got the hearing date, or when their position was when he received the ticket. And Judge Guild kind of, I guess, goes on a little garden stroll through this notion of disclosure in traffic court. But I thought he made some interesting points. He said, it's weird. It's weird that the person who is subject to the violation ticket allegation has to formally request disclosure during the dispute process, and that this isn't just provided as a matter of course. And then he refers to this decision of Judge Dome, who's the associate chief judge, where he said, look, it doesn't make sense to require full disclosure automatically on every ticket issued in BC. But Judge Guild says, I think it's different once the ticket's registered in dispute. Why wouldn't disclosure just automatically be provided in those circumstances? Now there's going to be a hearing if they're disputing the allegation.
Yeah, I don't know why it's not scanned to some file where a person is then mailed a code that they can log in and get a copy of their disclosure.
Yep.
I mean, this is something that's easy to do in our society with our technology these days. It's not, police officers, it's a bit of a pain for them. It takes a little bit more time, but it's not exactly something difficult to do. And if the person doesn't download it, I mean, they could see whether or not it's been accessed. If a person doesn't download it, then they got some explaining to do.
Yeah. Anyway, he comes to the conclusion that, there's no reason why the state's obligation to provide disclosure is only triggered on request in a violation ticket. So this case actually says, technically, the state has the obligation to get you the disclosure. He doesn't really go more further than that, and I think it's probably obiter, but it's interesting. So ultimately the delay application is successful. And he finds nothing wrong with how Mr. Newby acted. As soon as he got the hearing date, he sought disclosure. It wasn't his fault, that he got it the day before. There's no defense delay. And the ticket was, I think, 20 months and 11 days. So it was over the 18 months and presumptively unreasonable.
For a long time, you and I mused privately, mostly. I mean, much of what we discuss here is the things that we also discuss privately. And part of the idea of this podcast was to share our thoughts on these things. But for some time, we were not certain whether or not that Jordan timeline was going to apply to traffic tickets. And there was good reasons for that. It could have gone either way, right? You had your arguments for both ways. And now it seems pretty much confirmed, unless this ends up going to some higher level of court, not this decision. Most of the decisions we've seen have confirmed the 18 months for a traffic ticket. And, I guess the arguments that you've made in favor of that and my arguments going the other way, you've obviously, you win your can of Coke I promised you.
I always get my can of Coke, no matter what.
I know.
I
know.
Yeah. Anyway, it's time for the ridiculous driver of the week. You excited?
I'm always excited about the ridiculous driver of the week.
Great. So this week, our ridiculous driver of the week is everybody. It's everybody. It's you, it's me, it's everybody. Actually, it's not me, and I'll tell you why. The ridiculous driver of the week comes from this survey that I read about in Global News, and it's wild to me that this survey was even conducted in the first place. Like, maybe the ridiculous driver of the week is what idiot thought of this survey to begin with, but ICBC, that idiot, ICBC hired Ipsos with our lovely tax and ratepayer dollars to do a survey to find out how many BC drivers admit to tailgating or following too closely, and then also whether people don't like to be tailgated and how it makes them feel.
I've been forced to look deep into myself to address this because, yes, you have pointed out that it is me. And I suffer some shame, and I will defend ICBC here because, again, this is one of those public education things which has forced me to shamefully admit the failure of my ways.
Yep. Yeah. So that's that.
Well, you didn't quite explain it. What was the results of the?
Yeah, so that's the questions. So 77% of drivers, which is why I say it's everybody, because the other 23% are just lying, except for me. 77% of BC drivers admit to tailgating, and 86% of people say they don't like being tailgated, and it makes them angry or scared or intimidated. It's like, if there's 86% of people who don't like being tailgated and 77% of people tailgate, then you're doing the thing you don't like. You're all hypocrites. I don't tailgate.
So I'd say like 14 to 20% of the people are driving below the speed limit, like 40 in a 60 zone or 30 in a 50 zone. And, those people deserve to be tailgated. How else are they going to learn?
They should not be tailgated. It's very unsafe. And then there's 17% of people polled were like, the reason I tailgate is to prevent people from getting in. So I tailgate because I'm an asshole. A lane's ending. I'm not going to let somebody in. They need to change lanes to get their exit. I'm not going to let them in. I'm going to tailgate instead. Like, douche.
I'm letting people in for the most part, but I also, see somebody who's speeding up to try and get into that space that I've created. And I think, now I'm being forced back further. Now I'll create some more space. Oh, look, this guy's speeding up. He's going to try and squeeze in because this person behind me is tailgating me. So he's going to speed up in front of me. And he's not signaling. He's just speeding up to take advantage of it. I mean, okay, now I'm talking myself into justifying my
Tailgating.
my driving behavior.
Yet you don't like being tailgated. And then there's the
But I've never rear-ended anybody. Knock on wood.
then there's the next aspect of it, which is that people also were asked about what they did when they were being tailgated, and only 11% of people pull over to allow the tailgater to pass, which is what you should do, right? It's first available opportunity. Let them by you. Like, geez.
I have done that infrequently. Usually there's no spot to just pull over, right? If there's a spot to pull over, that's one thing. Pull over and then you've got 20 minutes before you get a break in traffic to pull back in. Now,
9%.
sometimes it's not realistic.
9% of people, though, deliberately slow down to send a message. And I am guilty of that. I do that. I will admit. I'm in that 9%. Somebody was tailgating me so bad the other day and it was heavy traffic. And I was like, I'm going to teach you a lesson. And I slowed down to 30 and like, he was so mad. But he got the message.
You're right in there. You're part of the stats.
Well, I don't have to drive fast. The speed limit is a maximum, not a minimum.
Yeah. Well, I remember back in psychology class where there was one of our textbooks talked about why people made decisions driving. And in the end, the final comment was, the psychologists are smart. And so therefore they drive well to send a message to others. Yeah. This was first year psychology, and I was very disappointed with that. That's a long time ago, but very disappointed with that. And I thought the sociologists would say to themselves, I'm just going to drive how I want to get there because nobody's paying attention to how I drive. And the historian would say, doesn't matter so long as you get it through. When you're dead, you're forgotten.
Yeah. There you go.
So just do your best not to hurt anybody.
Do your best not to hurt anybody. That's a good note to end the podcast on. Between now and next week, do your best not to hurt anybody on the roads, especially if you own a Bobcat.
Any vehicle.
Yeah. That's our podcast. If you have a question related to anything to do with driving law or you're charged with a driving related offense, you can give us a call at 604-685-8889, or you can find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.